Hello, everyone. My name is Tim Murphy. I'm the CEO for the Sacramento Regional Builders Exchange. I'd like to welcome you to this recorded webinar dealing with 2021 laws, what contractors need to know. Those of you who have attended classes at SRBX will probably know our next speaker, Lisa Ryan of the Cook Brown Law Firm. Lisa began her career as a policy consultant on labor and employment issues for the California legislature. Prior to her time in the legislature, she was appointed by Governor Pete Wilson to serve in the California Trade and Commerce Agency. Lisa is a graduate of the University of Pacific, McGeorge School of Law, where she wrote for the California Initiative Review in her honors in trial advocacy. And in addition to employment litigation, Lisa is also an experienced investigator called in to investigate workplace complaints and regularly conducts AB 1825 sexual harassment and employee conduct trainings for both public and private sector employees. So with that, I'll turn it over to Lisa. And Lisa, what can you tell us that our members need to know regarding new laws impacting the industry in 2021?
Well, thank you, Tim. This has been obviously a very busy year for all, but especially for California employers, no doubt. There's been a lot of activity in a variety of different aspects, but most importantly in with respect to COVID laws. So we're going to go ahead and start off talking specifically about laws that have been impacting employers in the COVID realm. So we'll start off with, most of us will remember back, if we go all the way back to March of 2020, this was obviously a crazy time. There were some major changes coming out from federal law. The Congress was rushing through some major changes, and a lot of folks remember with the FFCRA, there was a big push to rush through some paid sick leave that really impacted smaller employers. So a lot of listeners and folks that are joining us here, those that had under 500 employees. So come summertime, Governor Newsom decided, okay, maybe, we need to focus on some of the larger employers. And at that point, he passed an executive order that focused on those in the ag industry and some food service workers, employers with 500 or more. Then come September, the legislature passed legislation, AB 1867, that codified legislation and impacted those employers with 500 or more employees. So this bill was an urgency measure that went into effect in September and really only applies to those employers with 500 or more. It does impact those of you that have California operations that maybe even only have small presence in California, but perhaps some construction employers that have a presence that, maybe have under 50 here in California, but over 500 nationwide. So for those of you that may have impacted, it requires 80 or more supplemental paid sick leave hours for your employees who are impacted in a variety of different aspects related to COVID. So for those of you that maybe weren't aware of that, that is something that you do need to ensure is on your pay stub. It is above and beyond your regular paid sick leave requirements under the Healthy Families, Healthy Workplace Act. And it's something that I want to just make sure that everyone is aware of. It technically expires at the end of the year. So if you're listening to this in these last few weeks of December, just make sure that that is something that you have on your pay stubs and that you're aware of. That's a extra supplemental paid sick leave. One of the other big COVID changes, and we'll move on to the next slide, that everyone should be aware of is this COVID workers' compensation presumption. This is another one of these urgency measures that came out of the legislature at the very end of the session, so around the September kind of time frame. And most of you should have been contacted by your workers' compensation carriers to let you know that this was coming down the pike. And I don't want you to get too tied up in what it really means as far as your workers' compensation presumption, but you should be aware that this is something that you need to be notifying your carriers if and when you have a positive test in your workforce. So SB 1159 specifically requires you as the employer to notify your carrier anytime you have a positive case in your workplace. It's then up to your workers' comp carrier to try and determine whether the positive COVID actually occurred in the workplace. So basically whether they're going to accept it as a workers' comp injury, whether, you know, they're going to look and say, okay, is it presumed that it occurred in the course and scope of employment? Again, that's not really for you to determine. Your duty, your job is to report that. There's a variety of other things and information that you are going to have to fill out and report. Look to your workers' comp carrier for that information. Again, hopefully the takeaway from this bill is making sure that you have someone in your workplace that's designated to report this. There's a lot of information, and you'll be hearing when we get to the next couple of bills too, that there's a lot of different definitions that have been changed. And so I just want to make sure that you have someone designated in your workplace that's kind of tracking the information when you have someone that has been designated as positive. If we move on to the next bill, this is one that got a lot of attention, AB 685, and was causing, at least as of last month, a lot of worry for especially a lot of my construction employers. It was the AB 685 COVID notice requirement. Now, unlike the last two that were urgency measures and already in place, AB 685 is this new notice that goes into effect January 1. And this requires, for the first time, this was something that the legislature passed and said, okay, you employers are going to have to provide a notice to all of your employees at a particular work site when you have a positive employee, someone that tests positive in the workplace. You're going to have to provide notice to the other employees at that particular work site. Now, the notice requirements are very specific, and I don't want to get too in the weeds here, but again, this is another takeaway that I hope you have someone at your particular in your particular organization that's designated as your kind of COVID guru, your expert, that's going to be following this and ensure that they are going to be in charge of these notifications. You have to have specific information about what benefits are available to employees, the steps you're taking to protect employees, etc. The important part is that it's a really quick turnaround. You have one business day to turn around and get this information out to employees at the work site. There's other parts of this particular measure, such as notifying the California Department of Public Health, Cal OSHA. There's some information that, at different triggers that they may be publicizing certain workplaces if they meet definitions of what an outbreak is. And again, it's really specific in details as to what a work site, especially for our construction employers, what we define as a multi-employer work site is. So it was very heavy in definitions. We were working through all of this in November. It's still important. It's still happening come January 1. And, there's a lot of details that we can provide more information on, a lot of information on the website that's still out there that I want to make sure you have someone designated. But if we move to the next slide, I also want to make sure that everyone is aware that in addition to AB 685, a lot of folks have been hearing in the last couple of weeks, there also was emergency regulations that almost contradicted some of this information and some of the requirements of the AB 685 notice through these Cal OSHA emergency regulations. So in addition to the notice that is still happening come January 1 that you employers still have to comply with, that now effective November 30th, there is also an additional notice that you employers have to provide to employees who have also come in contact or have possibly been exposed in the workplace to someone that also tested positive. So it's a slightly different notice, a slightly different audience with respect to who that notice has to be provided to. It's very confusing, and again, a lot of details with respect to how it defines the workplace, it defines the audience, and you can see some other information here defining what an outbreak is, if you have 3 or more positive COVID cases, an exposed workplace. I know I'm getting a lot of calls with respect to some of these definitions, and we can help walk you through some of this. And I don't want to go into too many details, but we recognize this is a challenging time, and we just want to make sure that all of you employers out there recognize that there are very specific definitions and details out there that you have to walk through. So once again, trying to have someone within your particular organization that's designated to follow this and track what these requirements are, because it's very specific and detailed. One of the biggest challenges that a lot of construction employers are walking through is also trying to comply with the maintaining pay and benefits for individuals that have to quarantine during this particular time period. The governor just issued an executive order earlier this week that also defines what that quarantine period is. It's changing from 14 days to 10 days. So again, this stuff is changing as we speak, but the requirements continue. Moving away, we'll move to the next slide. Outside of the COVID requirements, but another couple quick bills we want to hit on that we just think it was really important that you're aware of, because this, in my opinion, is one of the most dramatic changes in my 20 years of doing employment law. And I think it's really important for all of the members here that to be aware of is a dramatic expansion of the California Family Rights Act. This, for the first time ever, changes who is the Family Medical Leave Act applies to. A lot of you that have fallen under the 50 or more employer threshold of family medical leave, it now applies to you. For the first time ever, California now says if you're an employer with 5 or more employees, you now have to provide protected leave to your employees. So this is the idea that 12 weeks or more protected leave is available to your employees to cover things like medical leave for their own medical issue, and or cover medical leave for things like taking care of, and you'll see down there, it's also expanding what is a family member, domestic partners, taking care of a grandparent, grandchild, sibling, possibly a parent-in-law. There's some debate right now about that definition, and even adult children. So for those of you that have been an employer with 50 or more, this also changes the definition of family under the CFRA. And we'll talk in just a minute about, we're going to provide some additional training next month that goes into much more detail about this dramatic expansion to CFRA as well. One other bill we wanted to just highlight for everyone, as we're just giving a little bit of a taste as far as some of the expansions to California, the California legislature did this year, was AB 2257. This was another tweak to AB 5. A lot of you that have been following the ever-changing independent contractor expansions and changes. This was following a few years ago, the changes following the Dynamax decision and AB 5. This is the ABC test that many of you, especially in the construction industry, have followed with respect to independent contractor changes. This was the most recent kind of tweak to the law. AB 2257, really some people a little cynical will say, hey, whoever had the best lobbyists have been able to get some carve outs and changes to the independent contractor law. A lot of us followed this year some of the changes with respect to Uber and Lyft drivers being able to get a carve out from the initiative process during the elections. This was one of the legislative changes. You'll see some of the carve outs for licensed landscape architects, registered professional foresters, things like that. The takeaway for me, I'd like to just share with everyone out there is to just really make sure that you're still being ever vigilant with respect to using independent contractors, especially in the construction industry. As you know, Franchise Tax Board, EDD, things like that, a lot of Labor Commissioner's Office are still being very strict when it comes to independent contractor relationships. And so that's not changing. Any of those types of relationships, you want to be very careful when you're looking at those relationships and taking a look at that ABC test. There has been some relaxing of the business to business rule, but again, I really advise you to seek counsel, talk to your attorney with respect to any of those types of relationships that independent contractor contracts that you may have. So those are just some highlights, some really just quick touches. I know Damon and Tim are going to talk about go into detail about some other of the legislative takeaways, but those are some ones I wanted to highlight. As I mentioned, I'm going to be partnering with SRBX next month. We're going to go really deep into handling leaves of absence. I know for one, it's something that I've been talking a lot with some construction employers about the challenges with handling leaves. A lot of questions I'm getting are with respect to having employees going out on workers' comp for months on end, or a variety of different needing leaves as an accommodation. And obviously things like this now needing CFRA or FMLA leave. So how do we handle this? A lot of you are small employers. These are challenging. How do you designate the leave? How do you provide the correct notices, get medical documentation, engage in the interactive process, things like that. And, we're designating a good hour and a half to go deep into the legal ins and outs with how to handle those kinds of questions, documentation, et cetera. So perhaps if you have someone in your office that you can designate to spend some time to really ask those questions and explore how to handle that the best way. We're going to go deep into that a little next month, January 28th. So with that, I'll turn that back over to Tim if there are any questions. I think you're muted.
Yeah, I do have a question in regards to the Cal OSHA ruling that did create some confusion with AB 685. When a contractor is looking at these circumstances, is there one agency? I mean, does Cal OSHA have precedent over the law of AB 685 after January 1st passes, or do you really have to get into the nuance about what the circumstance is? How would you advise a contractor to interpret both together?
That's a great question, and it's a real source of frustration for me, and I think for a lot of practitioners that I don't think that there is going to be one precedent over the other. Cal OSHA is taking, and even I think the governor is signaling that Cal OSHA has great authority to enforce their laws, and that they've given them great right to go in and, if anything, actually 685 provides even more authority with respect to investigating, following up, with respect to even not only doing IIP type investigations, having their reports, things like that specific to these additional rules in and of themselves. So Cal OSHA does have great authority, but even now the labor commissioner has different authorities to grant penalties, things like that. So I think that the answer is you have to do it all. You have to comply with everything. And unfortunately, it's not like a one or the other. You're going to have to, essentially do both notices. And not to scare people even further, but my concern is that there's also private rights of action. So I'm also concerned that there's private attorneys that are also going to be out there saying, hey, look, we're also going to swoop in and we're going to also be seeking to, file lawsuits as well. So unfortunately, there's going to be attacks from all different fronts.
You were going with my next question in regards to SB 1159. If the workers' comp carrier determined that there wasn't an infection caused on the job site, could the employer still be liable through other means of action? It sounds like they can.
Possibly, yeah. I mean, possibly that's subject to interpretation. I think that, again, that workers' comp presumption, I really like to leave that in the hands. I always try to tell my employers, leave that to the workers' comp folks. That's not your battle to wage. I know some people are captives and they're like, well, it is because it's money out of my pocket, and I get that. But again, with the workers' comp presumption, let them fight that fight and let them kind of, determine as far as whether that is actually, an industrial injury, so to speak, and fight those presumptions. But yeah, it's hard to predict. And I keep trying to tell people when they're making these decisions, it's also hard to predict what's a jury going to do with some of these things 6 months, 12 months, 24 months down. It's hard to predict how we're going to look back on 2020. It really is.
Lisa, should any of our members have any questions regarding your presentation, what's the best way that they can ask a question of you?
Yeah, they can always reach out. I mean, I'm at Cook Brown, so they can always go through, our website, www.cookbrown.com, or they can also email me at lryan@cookbrown.com.
Great. Lisa, thanks very much for that very informative presentation. We're going to move on now to the second part, where we're going to be talking about legislation with Damon Conklin, who is the Government Affairs Director for SRBX, and he's also the principal advocate for the California Builders Alliance. And Damon and his work addresses legislative issues concerning public works, civil and commercial construction and development. When he's not working for SRBX on behalf of our members, he also serves as an adjunct professor for Golden Gate University. He is a very capable advocate on behalf of our industry. So Damon's going to walk through some of the new laws for 2021 dealing with the construction industry side of things. Damon.
Thank you, Tim. I appreciate that kind and warm introduction. 2020 legislative session was definitely one that we will never forget, but would certainly like to forget. But I think it is worth looking back at the kind of the beginning of the 2020 legislative session to get to offer a kind of a backdrop of not only how we got to this point and what will likely be resurrected or at least introduced for 2021 legislative session. So, you know, as we know, we were all caught by surprise with the shelter-in-place orders that came out in the middle of March. And we fought really hard with our industry partners, working with the governor's office, demonstrating and providing evidence that construction was an essential service. Unfortunately, there were a couple of counties, LA County and some of the Bay Area counties, that still were withholding that recognition and were imposing several restrictions. We worked really hard with them to demonstrate to them and argue and defend that construction sites were safe and not only meeting but exceeding the safety protocols that were put in place. And thankfully, through those advocacy efforts, a lot of those county orders were relaxed and it recognized construction as essential and allowed that economic opportunity in those projects to open up. Of course, we had with the closure an economic component to the pandemic that has caused a vast decline in SB1 dollars that is paid at the pump that goes towards road transportation and maintenance. We've had reductions in tax revenues that businesses that normally would have been opened that were constricted down to the state. And so it left us collectively at the state with a $54 billion hole to fill that only got worse when there was a failure at the federal government to find an additional second round economic stimulus package that triggered another $11 billion hole for the state of California. So we'll obviously see what the next administration brings and what Congress can and cannot do in that regard. But things only got exacerbated with the wildfires that we saw not only in Southern California, but in Northern California as well. Those prompted Cal OSHA to impose some temporary guidances that, on respirators that I'll dive into momentarily. And also has set the stage that we've seen this year of a lot of organizations kind of doubling down in this greenhouse gas emission reductions and decarbonization for projects, both residential and new construction. So what bills should people be paying attention to, or at least should be cognizant of? The legislature had truncated their calendar, and there were 2 months where the legislature didn't meet, and there are probably many good arguments that many that are watching this are probably happy and relieved that when the legislature doesn't meet and doesn't find other ways of getting their influence into various industries. But what had happened though is typically we see about 3,300 bills introduced each legislative session. Those bills that were not COVID related, not pandemic related, were shelved. Authors were told by leadership to pocket a lot of those bills. And so that universe of legislation got quickly reduced down to 800 bills, about 200 in the Senate, 600 in the Assembly. And as a result, what we would normally see in a legislative year with a couple dozen bills impacting the both industrial, commercial, and residential construction industry, we really only saw a handful. And specifically to housing, after the demise of the well-publicized Senate Bill 50 that looked to rezone and upzone projects near transit and job-creating centers. After the failure of that, leadership and the governor unveiled this very ambitious housing package of about 35, 37 bills. And of course, every single one of them, with the exception of just a couple, all died in the process. And so we remained hopeful for another 3 years of promises out of the legislature for some relaxed CEQA or restrictions or fast track projects for affordable housing. Just wasn't there. But there were some bright marks, and allow me to at least draw everybody's attention to those. At the top of the screen, we'll see AB 3087. This was actually something that SRBX helped co-sponsor and was with the CSLB. And this allows for greater testing facilities being held by third-party vendors. For those that want to enter into the industry, allowed for a third party to hold these testing centers peppered throughout the state in multiple languages, which really kind of opened up, if you will, the opportunities for those licensing facilities to take place. Of course, with the shutdown, those hasn't been really fully realized, but we're hopeful in the coming months that those expanded testing capabilities will be realized. The Senate Bill 1474 is retroactivity on reinstate expired license. Now on this one, this was actually part of a much larger bill, but it requires a CSLB registrar to retroactively reinstate expired construction or contractors licenses if the completed license renewal application is received with all the appropriate fees within 90 days of the license expiration date. And so previously, though that wasn't able to take place, but with this bill, it did. Again, these bills are very minor kind of nano tweaks, if you will, for the industry at large, but for those that are trying to get into the industry, welcome news. And then lastly, on just the CSLB oriented bills, Senate Bill 1199, this created a new classification, a B2. Prior to this bill, whether you're building a home or building a skyscraper, the contractor's license requirement is the same. And so it's a one size fits all, which unfortunately, we saw some issues back in the 2017 fires in the Santa Rosa area, where by and large, most of the construction activity was done. It was done within the scope of the contractor's abilities, but there were reports from homeowners that some contractors kind of bid on jobs that were outside their scope. So what this does is it creates kind of a handyman or a remodeling construction worker classification. Doesn't involve and is not allowed. There's prohibitions against rough carpentry and basically what you would find in stick and frame, but really kind of narrows their ability to help with those homes that have been damaged by fires. And so this classification allows that, and basically create about 22,000 handymans that normally would fall under the license classification, pull them out from the shadows, and really help professionalize the industry overall. What we also saw was out of the fires, several bills were introduced, specifically bills that would have prohibited any construction, residential or commercial, in very high fire hazard severity zones. We got engaged with those authors of those bills and indicated and at least educated to them about how that, when overlaid with prohibitions on construction in flood zones and earthquake zones, that it would have shut off virtually construction over a plurality of the state and immediately shut off about a third of the state of construction. And that was not going to help us reach our goals of building affordable homes and also a lot of the commercial projects that were in the pipeline. So what we did is we helped the authors of a couple of those bills to pivot. And one of these bills was AB 3074, which created a new zone 0, if you will, ember resistant zone. So this bill essentially it creates some protections from the ground, from the building to about 10 feet. And then zone 1, that's already existing, 10 to 30 feet, and zone 2, which is already codified in statute, existing from 30 to 100 feet. So it creates that initial zero, first immediate few feet outside of the building, and provide some enhanced protections to prevent embers from combusting and catching that dwelling on fire. And again, it does apply to both residential and commercial. And so that's a one to pay attention to. Would also like to draw attention is AB 1561. Again, this was something that we worked with our industry partners, the California Builders Industry Association, CBIA, on. It is affordable housing, but it does apply to mixed use and commercial applications. I know a lot of our member companies build apartment dwellings, so this would apply. It allows for an 18-month extension on those entitlement permits. So those that were pulled in March of this year and were set to expire at the end of December of this year have now 18 more months to be able to move forward with those projects without any new documentation. So that was a welcome news for the construction industry, and definitely one that we applauded both the author and the governor for signing. Lastly, I'd like to at least just draw some attention to kind of piggyback onto what Lisa had highlighted. Cal OSHA did put out some regulations. First and foremost, back in September, they issued some temporary guidance around the N95 masks and the issuance of those. A lot of contractors were scrambling to find suppliers when the wildfires came and the air quality index had hit and triggered the 150 point level and exceeded. In some areas it got as high as 500, and had donated as an industry to frontline healthcare workers the N95 masks. Well, supplies were shorted, and these guidances allowed for at least from outside vendors outside the United States that were NIOSH and KN95 approved to be utilized, but it also provided some good faith adherence to these and recognize that if an employer happened to be out of compliance, if they could demonstrate that there was some good faith attempts to acquire these masks, that they had be able to show some shipping orders that were delayed or something, that it would allow them to not come under the any penalties or fines. So that was some welcome news, but definitely something that we will most likely see next year. And then finally, really, and this is kind of goes back to that original comments of Lisa about 685 and the Cal OSHA regs on reporting on employees on COVID infections and testing positive. We're working with the division on providing them with some information. So we're encouraging members that are finding some frustration with these overlapping statutory requirements on top of these immediate emergency regulations that have been adopted and are in effect today. Where you find there's ambiguity, confusion, specifically 685 recognizes workers, but has different definitions for them in the temporary emergency regulations. Ways of communication, 685 identifies, written communications to employees, where the temporary regulations doesn't have that. They both treat independent contractors differently. So when you as an employer find those confusions or the ambiguities or there's inconsistencies, please share that with us. We're going to be working with the division moving forward in the early part of January to go back and revise those. So we're part of a working group with Cal OSHA and some of our industry partners to try to find some middle ground, at least to want to keep employees safe, we want to keep the job site safe, but we also want to strike a balance with employers and being able to do something that they're capable of doing and not being asked to comply with an ever-moving, ever-changing set of regulatory requirements. So please pass that information along to us. We will go and represent
No, but I will say that, first of all, thank you very much for that look ahead at 2021. And just for our members to know this is that our advocacy is one of the most important benefits that you may not be aware that SRBX provides to you. As you've heard, SRBX has been involved through Damon's efforts in stopping onerous legislation from going forward, helping to minimize regulatory impacts upon our member companies, and also on the other side of the coin, promoting common sense legislation that helps our industry. And certainly we always take the opportunity to educate our lawmakers to help them understand that while their intentions might be good, California, especially construction industries in California, it's not a one size fits all state. And so educating legislators as to the nuances and challenges that construction might have in complying or responding to what their proposals are, getting exemptions for those. And so our advocacy actually saves our members time and it saves you money. It's hard to quantify what that amount is, but suffice it to say, we save our members thousands of dollars a year through our legislative advocacy. So that is our look ahead to 2021. Before we sign off, Lisa, is there anything with 2020 laws as we record this? There's 2 weeks left in the year. Are there any deadlines that our members should be cognizant of regarding laws that are in effect for 2020?
I guess just a couple things just to remind your members before the end of the year. I mean, one of them is the sexual harassment requirement training. We're coming up on the end of the year here, and that's something I'm getting a lot of calls just asking, was there any waiver because of COVID? And the answer is no. There was a postponement about a year ago. that gave most all employers until the end of this year to make sure that all employees were trained. That's the requirement, that all employees have the 1 hour training and supervisors have the 2 hour training. And just to FYI, now DFEH has free training on their website. So even, all your construction employers, it's a little bit harder because they're not sitting at a desk. It's a little bit harder to get them in front of a computer. I realize that. But I've seen some construction employers get pretty creative with, setting up on job trailers and things like that to set up computers. And there's some different ways to do it, but that is available to them now at the DFEH website free. And so I really recommend trying to figure out a way to get their employees trained before the end of the year and save those certificates. And then the other takeaway, just again, it's not a new law, but just remember that come January 1, track those minimum wage hikes, because not only just if you're not paying not just the minimum wage, but that 2 times the minimum wage for things like if you're not providing hand tools, for the exemptions, things like that. When you're trying to do things for the 2 times the minimum wage, that's really getting to be quite high now for California employers. So just making sure that you're tracking that as well come January 1.
Great. Lisa, thanks for those reminders.
Absolutely.
And again, just to remind our members, we do have a webinar with Lisa on handling leaves of absence. That will be on January 28th from 9 to 10:30 p.m. As always, you can get information on our upcoming classes at www.srbx.org. So on behalf of Lisa and Damon and the SRBX team, I would just like to wish everybody a happy holiday season. And as always, thank you very much for your membership in SRBX. Build safely, everyone. Thank you.